Hi, my name is John Lindsay. I'm an intellectual property attorney. Before I became an intellectual property attorney, I was in information technology for about 10 or 15 years or so in various positions, primarily as a software developer, application architect, software engineer, and various similar positions. So, as an intellectual property attorney, I frequently get the question, how do I, quote, patent my website or copyright my website or trademark my website? And that's somewhat of a misnomer to refer to it that way. And the process that is typically employed in protecting the assets or individual elements of a website are to break down those individual elements and apply the common intellectual property regimes to the elements of that website. So let's step back for a moment. We'll step through the common regimes, and then we'll bring up an example or two for those common regimes that may apply in a website scenario. So, the most common intellectual property regime, or arguably well known, is the patent. Well, typically, patents protect products or processes. So, with that being said, probably one of the most common software or website related patents is probably the Amazon one-click patent. In that case, the patent office deemed the procedure that made a smooth process for website visitors to order merchandise was deemed patentable at that time. So, at looking at your website, that's something that you need to explore. Or in a more modern context, cloud computing is a large issue, and one of the big concerns, of course, is the security in storage of the data and security in transmitting the data. Well, one of the older patents was the Diffie-Hellman patent, or public-private key exchange, and so perhaps there's an innovative, unique, and non-obvious process that's being employed in your website that may warrant exploration of a patent application. One subset of patent protection is also called a design patent, and it doesn't have that functional aspects that the traditional utility or product and process patent that we just spoke about, but I want to bring this up as well because it does apply in the website scenario. The design patent, again, it protects the aesthetics or the look and feel, and one of the most popular examples of the design patent in the website context is actually the Google homepage, that minimalist style, and actually Google was successful in their design application for that. So let's move on to copyright. Copyright typically protects artistic expression or the content of a website. So there are three main areas that we'll speak about today that relate to the content. One of them are, of course, the pictures. The other is the content itself, the words. Another is the source code. And a subset of that actually is the overall layout, so that the pictures and words produce a certain screen layout for an individual page that may warrant copyright protection as well too. So stepping back, pictures, for example, if there are unique pictures that you believe have value on your website, well, we may explore copyright registrations for those. Or if it's unique text, if it's the text that is the value of your website, well, then we might seek copyright registrations for those. Or perhaps there's a unique screen that has a look and feel, we may explore a copyright registration for that. And relating to the source code, it's actually possible to file a copyright registration for source code as well too. It may or may not make sense, but nonetheless, that could be something that could be explored in relation to the website as well. Trademark. Trademark is typically thought of as the branding. How does that relate to the website? Well, one of the common examples, of course, Twitter. Of course, that branding applies not only to the website, although it could apply only to the website, but it's a general asset of the business, Twitter. I mean, we all know and love that name. And so originally there were a lot of applications that were created that had Twitter in the name. Well, you'll notice these days if you try to create your own application and it has Twitter in it, when you try to register it at the Twitter website, you'll be denied based on trademark grounds. So that's another aspect of trademark protection that can apply to a website. There's also a subset of trademark protection called trade dress. The brick and mortar example of that is actually Taco Cabana, that pink or mauvish sort of color that they have with the umbrellas that lets you recognize it from a distance. If you're coming down the highway from a quarter mile away, you'll see that and you can easily say, hey, that's a Taco Cabana, that's a source for tacos, hey, let's head there. It's the protection of the ambiance or the look and feel. So in a website that's selling merchandise, and perhaps it's high-end merchandise, jewelry or something like that, that the customers need to see the surrounding aesthetics in order to appreciate the website, well, we may explore trade dress protection for the website. So, in closing, I just want to repeat that we don't patent a website or copyright a website or trademark a website. We look at the elements of that website and we apply the intellectual property regime to those elements to see what may or may not be worth seeking protection on. So if you need some intellectual property support in analyzing your website, feel free to contact me. Thanks a lot. Take care.